welcome to Crime in Court. This is the trial of Richard Allen in the Delphi homicides, and we are going to go over some new motions today. And unfortunately, this is going to be voiceover only, not feeling the greatest after going to a doctor's appointment today and just like walking, doing a lot of walking, which I wasn't prepared for. My body after my hip surgery, not really ready for it. But, anyways, so I'm just gonna go off camera for this video, and it might be part one of two just because I'm not feeling the greatest. So, let's get started here. I have four motions to go over with you, and then a lot of exhibits, and there's some bombshell newsworthy items that came out in these filings. So I definitely want to get into it. Let's get started. Please hit the like button and let's begin. All right, so let me actually make that a little bit bigger. So this first motion is the defendant's motion for hearing on a motion to correct error. We will read through the motion to correct error. This is basically saying that they want a hearing. So the defendant, Richard Allen, by counsel, respectfully requests that this court set a hearing on defendant's motion to correct errors. In support of this motion, the defendant states the following. The defendant has filed a motion to correct errors contemporaneously with this filing. In his motion to correct errors, the defendant requested that the matter be set for a hearing. Indiana Trial Rule 7C requires a party requesting a hearing to file such a request by separate motion. Wherefore, the defendant, Richard Allen, by counsel, now respectfully requests that this court set a hearing on his motion to correct error and for other just and proper relief in the premises. So this was written by Jennifer Auger, Andrew Baldwin, and Bradley Rosie all signed it. So that's the first motion, and we'll get to the motion to correct error shortly here. So the next motion is the motion to preserve specific evidence. Comes now Richard Allen by and through counsel and moves this court order the state of Indiana, including the prosecutor's office and all law enforcement agencies, labs, or state, federal, and local bureaucracies that possess any of the following evidence to preserve said evidence and not destroy or lose said evidence. This is now their second motion for a motion to preserve evidence. And the last time she denied it, saying that their motion wasn't specific enough when they said all evidence, preserve all evidence in this case. So I guess she didn't like that. So this is their specific motion for evidence. Said request is made for the reason that said evidence may be used at any future trials should this case ever be retried, or may be used by future post conviction lawyers in the event that the matter is not overturned by appeal. Richard Allen's attorneys request the following specific evidence to be preserved. Number one, all physical evidence taken from the crime scene or near the crime scene, including any belts, cigarette butts, or any electronic items, whether or not they were working. What does that mean? Was there another electronic item that might have been found that was broken and they didn't do anything? Was there maybe a phone or something? I don't know. This is really making me think that they had some other kind of electronic device and they didn't do any kind of forensic testing on it. And number two, all DNA swabs taken during the investigation or even during trial or afterwards. Wait, what? So they're still taking DNA swabs even though the trial's over and they got their conviction that they were celebrating and patting themselves on the back for? Gross. All forensic evidence obtained during the investigation or even during trial or afterwards. So if they are still investigating, uh, they want that disclosed to them as well. and preserved. Any and all reports or lists that identify anyone whose interviews were erased while in possession of law enforcement or the state of Indiana. Well, we know that's in reference to the certain individuals that just happen to be mentioned in the Franks memo, like Brad Holder and Patrick Westfall, those guys, Elvis Field. Their interviews just happened to get erased. All evidence identified on the state of Indiana's exhibit list or that may be exculpatory in nature. So anything that's on the state of Indiana's exhibit list, you can't get more specific than that. I mean, every single item listed. Okay, Judge Goal, is that specific enough for you? The items identified in 1 through 5 are not intended as an exhaustive list of items that that the defense is requesting this court to order preserved, but rather are a few of the specific items that the defense is requesting following this court's previous denial of the defense's request to preserve evidence for lacking specificity. I roll here. That's where I rolled. And I'm sure the defense did too. They're like, seriously, we have to do this again. In the meantime, we gave everybody a heads up that we're filing this. And so if they want to get rid of some evidence between now and preservation order, Gold just gave them a whole bunch of time to do that. So F her. If you hate her, you don't hate her enough. And wherefore Richard Allen requests this court to order the state of Indiana to preserve the evidence as detailed herein. Here is a motion to correct abstract of judgment. So, defendant Richard M. Allen, by counsel, respectfully requests that this court issue an amended abstract of judgment. In support of this motion, defendant states the following. On December 23, 2024, this court issued an abstract judgment in this case. Under Part 4 of the form, the court indicated that there were no mental health concerns with defendant. Yet at trial, evidence was presented that defendant had significant mental health concerns throughout his case. Dr. Walla, Dr. Martin, and Dr. Westcott all testified about defendant's mental health issues. Video evidence revealed behavior by defendant while awaiting trial that raised concerns about his mental health as well. So how on earth she got to there were no mental health concerns for the defendant is beyond all of us. She just makes up her own rules, Judge Gall. Providing accurate information on the abstract of judgment is critical to ensure the DOC is aware of defendant's mental health issues, so the defendant will receive continuity of care and appropriate placement, effective treatment, and medication, etc. Wherefore, defendant by counsel respectfully requests that this court issue an amended abstract of judgment reflecting the change in the answer under mental health concern from no to yes. Defendant additionally requests that this court forward a copy of the amended abstract of judgment to the Indiana Department of Correction, and that's from Andrew Baldwin, and that's got to affect his treatment within the DOC, and that's why he's asking for this to be corrected on the record because he's not getting the treatment that he needs while there. I mean, I'm sure most prisoners don't get the treatment that they need, but at least, some might offer some sort of treatment, at least, some sort of medication or some kind of maintenance, something or other, even if they aren't doing it like here you have 14 different kinds of prescription medications that you can choose from. It's no, it's like everyone in the prison gets the same thing, probably, but And whether it works for you or not, you're just out of luck. If it doesn't, I guess. I don't know. I don't think that they have the greatest mental health facilities in prison, but especially after knowing how Dr. Walla came in from off the street and happened to be in every single Delphi chat room or forum that you can find online or on social media. She was there and she was talking about the case when she was simultaneously treating him. So that is a whole bunch of ethical problems if you couldn't tell. So yeah, so Dr. Walla, we're not a fan, and mental health while he's there, I'm not really sure he's going to get so much. So, anyways, let's move on to the final and the big one. This is where all of our bombshells are going to come in. So, this is our final motion, but it is a 24-page motion. I'm probably not going to read through all of it in this part because we're going to be going back and forth between that and this motion and many of there's many attachments, so just bear with me. I'll even pause in between and get my attachments readjusted when I need to here, but just letting you know we're going to go back and forth between this document and some others. So this is the defendant's Richard Allen's verified motion to correct errors. This is what he's asking for a hearing for, to discuss the errors that they are going to lay out here in this record. And this is so important. As we know, Judge Gold is probably just going to deny all of these without even reading them, but and without hearing, but at least it's on the record and it is uh, then it's on the record for his appellate team to work to get something going in the works there. So, anyways, let's get started. So, defendant Richard Allen verified motion to correct errors, multiple errors. Comes now the defendant Richard Allen by counsel and files his verified motion to correct errors. For the reasons that follow, the court should either vacate Mr. Allen's convictions, so just get rid of his conviction of first degree homicide twice over, get rid of those convictions, or set the matters for a hearing. So they want a hearing, or you need to vacate his conviction altogether, which is actually the proper remedy in this case for what they're about to lay out. But she's probably just going to deny it because she's corrupt as hell. So let's get started. In violation of the Sixth and 14th Amendments, Mr. Allen was deprived of counsel at the safekeeping proceeding of November 3rd, 2022. That proceeding was a critical stage at which Mr. Allen was entitled to be represented by counsel, and under United States versus Chronic and its progeny, the court must presume that Mr. Allen was prejudiced by being underrepresented during the proceeding. So by not having his attorney there, he was prejudiced. There was prejudice towards his side. Um, all right, so Indiana Code 353311(1) governs safekeeping proceedings for pretrial detainees and provides in full transfers for personal safety or safety of others. Upon motion by either the sheriff, prosecuting attorney, defendant, or his counsel, attorney general, or the court, alleging that an inmate in a county jail awaiting trial is in danger of serious bodily injury or death, or represents a substantial threat to the safety of others, the court shall determine whether the inmate is in imminent danger of serious bodily injury or death, or represents a substantial threat to the safety of others. If the court finds that the inmate is in danger of seriously bodily injury or death or represents a substantial threat to the safety of others, it shall order the sheriff to transfer the inmate to another county jail or to a facility of the Development of Correction designated by the commissioner of the department as suitable for the confinement of that prisoner and provided that space is available for the purpose of that prisoner and provided that space is and provided that space is available, period. That was a long sentence as it was. Didn't need to make it longer. So basically, if the court finds this, yes, if the court finds for whatever reason that the inmate is in danger, then they can move him. So, for the purpose of this chapter, an inmate is not considered in danger of serious bodily injury or death due to illness or other medical condition. Indiana Code 353311-2 also governs safekeeping proceeding for pretrial detainees and provides in full a post-transfer hearing right of inmate to refuse transfer. And this, so he didn't have his. Okay, let me back up in case you're not aware. I think I've gone over this before in my channel, but just in case I haven't, or if you don't remember. So, when Richard Allen first was taken into custody, he was first arrested. He was basically transferred without not basically, he was transferred to Westville Correctional Facility, which is where they tortured him in solitary confinement for over 15 months and had Dr. Walla and other people staring at him and watching him 24/7, calling it self-deletion watch, but really they just wanted to probably get to him. Who knows what the people were saying to him that were supposedly watching him. A lot of them were inmates at first, and then it was corrections officers, which aren't any better. So, I mean, I don't know, whatever. So he was sent to Westville, but he had representation at the time, even though they didn't recognize it. So there's a disconnect here where they sent him to Westville, but he was already under representation because Kathy Allen had already, and we'll actually see a receipt where she paid the retainer for an attorney for him. So this is why this is so important. They transferred him without an attorney and without his right to refuse. He has a right to refuse transfer. They transferred him hours away from his attorneys, hours away from his wife and family, and he didn't have a say in it. So it's very scary that the government can just do that. So here is the post-transfer hearing right of inmate to refuse transfer. The inmate or receiving authority is entitled to a post-transfer hearing upon request. The inmate may refuse a transfer if the only issue is his personal safety. And that is the only issue that we know of that we are being told as to why he was transferred. So, and there's still, then he was transferred again under like the darkness of night after he had been tortured for 15 months in solitary. And then they send him to another prison that's even farther away. And like it just doesn't, his incarceration has not made sense. So Mr. Allen was interrogated and arrested on October 26, 2022, and booked into the Carroll County Jail under a pseudonym. The next day, October 27th, 2022, Kathy Allen, Mr. Allen's wife, hired attorney Brett Gibson. You catch that? The very next day, October 27th. So this is represented in Exhibit 1, which we're going to skip over to here, which is an affidavit of Kathy Allen. The affiant Kathy Allen, upon her oath under penalty for perjury, says, I am Richard Allen's wife. On October 26th, 2022, my husband was interrogated, arrested, and jailed. The next day, October 27th, 2022, I paid Brett Gibson, a lawyer in Lafayette, $5,000 to represent my husband. So, on record for, he needs to notify, obviously, the court to let them know that he's represented, but he is definitely, once that retainer is signed, you're good. So, Exhibit 1, 1A is an email I received from Mr. Gibson's office acknowledging that I had paid Mr. Gibson to represent my husband. Take a look at that. This is payment receipt from Gibson Law for $5,000. And from Gibson Law Office, we scroll. This is payment receipt, 5,000, account holder Kathy Allen, and it was received October 27th, 2022 at 6 p.m., 6:02 p.m. to be precise. So at that moment, Richard Allen is represented. The evening of October 27th, 2022, Mr. Gibson sent a letter by email to the Carroll County Sheriff. So the very same day, that evening, he sent a letter to the sheriff and Nick McClelland, our good old boy Nick McClelland, the Carroll County prosecutor, telling them that he was representing my husband and they should cease all questioning of him. So at this point, whatever you're doing to him, you need to stop. Exhibit 1B is a copy of the letter sent to me by Mr. Gibson. So we will flip over to that now. This is Defendant's Exhibit 1B, Gibson Law Office, Carroll County Sheriff. This is to the sheriff, and I'm sure Nick McClelland got the same exact letter just with his name on it. Or no, he didn't. He's just copied. So it's sent specifically to Carroll County Sheriff, which is Tobe. No, sorry. Tobe Lesenby was the sheriff just prior, and Tony Liggett then became sheriff right after maybe it was Tobe. I gotta go back because there was a election for sheriff, and it was between Tobe Lesenby and Sheriff Liggett, who now Liggett, and there's some, I think, some weird, I can't remember the full story, but anyways, it was right around election time when Richard Allen was arrested. I can't remember if he was arrested first and then there was the election or if it was vice versa. I think he was arrested first so that Tony Liggett could run on that. I don't know. But anyways, so here we go. Dear Administrator, please be advised that I have been retained to represent Richard M. Allen in certain matters relating to an investigation being conducted by your office. It is my understanding that my client is being detained by Carroll County Sheriff. He so so he's with the sheriff right now, supposedly. So then why the heck was he given to the Department of Corrections? Because that's not the same. I mean, they're a separate entity. So he will not be giving any statements regarding this matter. If he is currently being questioned, the interview should be terminated. Don't question my client. If you have any comments or questions, please do not hesitate to contact me. I can also be reached at email. Thank you. And he signed it, and then he copied jailer, sheriff. So that's the sheriff, and then Nicholas McClelland. So that was Exhibit B1. All right, next is about 10 p.m. Mr. Gibson called me to say he would not be able to get my husband out of jail because he was going to be charged with homicide the next day. The affiant says nothing more. So she doesn't even know what the heck is going on and why he's being detained. She gets a lawyer for him, and here we go. He's being charged with homicide. Um, So, I mean, she had an idea. It's not like she was totally in the dark because they were questioning him at the police station and they brought her into the room and saying like, you don't want to disappoint your wife, do you? You want to do the right thing, trying to guilt him into falsely confessing to something he didn't do. All right, let's move on now. So, in the evening of October 27th, Mr. Gibson sent a letter by email to the Carroll County Sheriff's Office and to Nicholas McClelland, the Carroll County Prosecutor. Exhibit 1B. We just looked at that. What emerges from defendants' exhibits 1C and 1D is the following. Sheriff Lesenby, so it was Lesenby at the time, confirmed receipt of Mr. Gibson's letter by telephone the evening of the October 27th. So Sheriff Lesenby confirmed that he received it. However, also on the 27th, however, over the telephone, someone at the Carroll County Jail told Mr. Gibson that Mr. Allen was not an inmate. Mr. Gibson then contacted Mr. McClelland by email, after which Mr. McClelland called Mr. Gibson on his cell phone. Mr. McClelland told Mr. Gibson that Mr. Allen was listed at the jail under a different name, an alias. So somebody arranged an alias name for him. Um, but it, but they arranged for Mr. Gibson to meet with Mr. Allen, even though they had him under an alias. Mr. Gibson went to the Carroll County Jail where someone from the sheriff's office took Mr. Gibson to a meeting room. It appeared to Mr. Gibson the regular jail staff did not know Mr. Allen was there. Okay, so did they lose him? Still, on the evening of October 27th, Mr. Gibson met with Mr. Allen and advised him not to discuss his case over the telephone because calls can certainly be recorded, would certainly be recorded. So I'm going to skip over now to exhibits 1C and 1D. So kind of backing up a little bit here. This is defendant's Exhibit 1C, it's an affidavit of Bradley A. Rosie, who is one of the defense attorneys for Richard Allen. The affiant, Brad Rosie, upon his oath, under penalty for perjury, says, I am a lawyer with a law practice in Logansport, Indiana, and have been a lawyer in good standing in Indiana since I was admitted to the Indiana bar on June 7th, 2002. Since November 2022, I have been the attorney for Richard Allen, who is the defendant under the case or this cause number. In an attempt to learn whether Richard Allen's first attorney, Brett Gibson, had communicated with either prosecutor Nick McClelland or then Sheriff Tobe Lesenby or any other law enforcement officer concerning the fact that he, Gibson, was representing Richard Allen effective October 26th, I reached out to Gibson via email asking him a series of questions. The purpose of my inquiry was to determine whether McClelland, Lesenby, or any other law enforcement officer was aware that beginning on October 26th, attorney Brett Gibson was representing Richard Allen after Richard's arrest on October 26th. So she was to reach out to him on the 26th, but didn't get the payment to him until the 27th. So, um, or the email, I guess, from him till the 27th. Didn't go through. I don't know. But anyway, so they're saying he was represented on the 26th. Right? This says the 27th. Payment date 27th, but they might have met the day before and it didn't go through, the payment didn't go through till the next day. I'm not really sure, but something along those lines. So, um, where did I leave off? Okay, so at about 10 p.m. on October 27th, 2022, Mr. Gibson called Mrs. Allen to say he would not be able to get Mr. Allen out of jail because he was going to be charged with 2 counts of homicide the next day. And that was Exhibit 1. We already saw that was her affidavit. Okay, so on October 28th, 2022, without Mr. Gibson present, even though Mr. McLeland and Sheriff Lesenby both knew that Mr. Allen was represented by Mr. Gibson, Mr. Allen was charged with 2 counts of homicide, and Judge Diener held Mr. Allen's initial hearing without his attorney present. That is so wrong. Shortly after his initial hearing on October 28th, Mr. Allen was whisked away from the Carroll County Jail to the White County Jail without a safekeeping order authorizing the transfer. So he was moved without an order. How does that happen? On November 1st, 2022, a letter from Mr. Allen was mailed from the White County Jail to the Carroll Circuit Court. The letter and the envelope are part of the record in this case. In that letter, Mr. Allen requested that the court appoint counsel for him. Nothing in the letter indicated he was not already represented. For some reason, although it had sufficient postage and was correctly addressed to the Carroll Circuit Court, Mr. Allen's letter requesting the appointment of counsel was returned to the White County Jail. Man, they've been doing shady BS from the start. This shit pisses me off. Like, oh, we didn't get that letter. Just return it. Okay. Just pretend you didn't get that. It was then remailed from there and is shown filed in this court on November 9th, 2022. That was an error. Under the mailbox rule, as a matter of law, Mr. Allen's letter was considered filed with the courts as of November 1st, 2022, the day his letter was mailed from the White County Jail. The prison mailbox rule, recognized by the United States Supreme Court in Houston versus Lack, provides that pro se filings from an incarcerated litigant are considered filed at the time they are delivered to prison authorities for forwarding to the court. Bam! And that's Lawrence versus State. The safekeeping proceeding was plainly illegal from start to finish. First, Sheriff Lesenby transferred Mr. Allen to the White County Jail on October 28th, 2022, with no safekeeping order in place. Next, Sheriff Lesenby had no standing to make the safekeeping request on November 3rd due to the fact that Mr. Allen had been illegally transferred to the White County Jail on October 28th. Once Mr. Allen was in the White County Jail, the White County Sheriff was the sheriff statutorily authorized to make a safekeeping request under Indiana Code 353311-1. See, this is what happens when you F around and find out. These people don't play by the rules and they're just going to be like, you know what? The law doesn't apply to us. We got the bad guy. Let's just go ahead and throw him in jail. Let's transfer him. Let's torture him. Let's do whatever to get the confession out of him. And we don't need to even, you know, uh, apply our own rules that we have been, that we gave an oath to uphold and protect. It's just ridiculous. All right, so because Sheriff Lesenby had no standing to make the safekeeping request, Judge Diener had no jurisdiction to consider it. highlight that because I like that sentence. Whoops, why did it stop? So, no jurisdiction in either way. So, Sheriff Lazenby and Judge Diener. Because Judge Diener had no jurisdiction to issue the order, the safekeeping order was literally void. So, it was literally just like as good as a blank piece of paper. So, which judgment is void if it grants rights or reliefs to a party that does not have standing to pursue the action. So it's like it doesn't even exist. All right. So second, Mr. Allen had the right to have a judge other than Judge Diener decide whether to issue a safekeeping order at Lesenby's request. That is because Judge Diener had engaged in ex parte communications with Sheriff Lesenby. This means that they've had communications without defense around, without, representation for the defense. So that's not allowed. You can't have judges just having conversations on the side with law enforcement and prosecutors or defense attorneys either. So you can't have it one way. They have to both be present so that there's, or if the other side, if a defense attorney is perhaps going to speak with someone, maybe a witness or whatever, they would often bring like another person so that they're not alone with that individual, so that they can say, there's a, it's not just the lawyer's word against, the witness or whatever. In case something changes, there's always going to be like a third party there. So that's why they do that, because you need to be protected. You got to have all sides around. So um, this judge, apparently, Judge Diener, had been engaging in ex parte communications with Sheriff Lesenby, helping Sheriff Lesenby draft his safekeeping request. So okay, he helped him write it in violation of Rule 3.10 of the Code of Judicial Conduct. Wow. You guys are screwed, is what I'm going to say. I think Judge Gull, Judge Diener, Lesenby, I think all of Jerry Holman for sure. I think the FBI should be looking at them if they aren't already. All right. Where do we go? All right, so Rule 3.10 prohibits judges from drafting or reviewing documents except for family members. Judge Diener also violated Rule 2.9, so another violation, of the code by engaging in substantive ex parte communications with Lesenby, which helping Lesenby draft the safekeeping order certainly were. So, having violated both rules 3.10 and 2.9, Judge Diener was obligated under Rule 2.11 of the Code to recuse himself and request appointment of a special judge before he issued the safekeeping order, not after, which is what he did on November 3rd. All right. So third, Sheriff Lesenby's November 3rd, 2022 request for the Sheriff of Carroll County, Indiana to transfer inmate from the custody of the sheriff to the custody of the Indiana Department of Corrections for safekeeping was not served on anyone. There is no certificate of service attached. Indiana Code 3533.11.1 requires the safekeeping request to be made by motion. Indiana Trial Rules 5A2 and 3 required that Sheriff Lesenby's motion for a safekeeping order be served on all the parties. Because Sheriff Lesenby knew that Mr. Gibson was representing Mr. Allen, he was required to serve Mr. Gibson with his motion for a safekeeping order. Even if he claims Mr. Gibson was not representing Mr. Allen at the time, Sheriff Lesenby was not required to then, or was then required to serve it to Mr. Allen personally. So you, you know, i- if your defendant or um, what would you call your alleged um, criminal, if they are, um, I just totally lost my thought. Um, Forget it because I seriously don't remember now. Even if he claims Mr. Gibson was not representing him, Mr. Allen, at the time. Oh, so even if you think that your criminal is not represented by an attorney, you still have the obligation to serve them with those papers, whatever the order, the safekeeping order, even if he doesn't have an attorney. So either way, he should have received it in some form or fashion. Fourth, Sheriff Lesenby's safekeeping request was not verified. There was therefore literally no evidence before Judge Diener from which he could make any factual finding required by Indiana Code 3533.11.1 that would authorize a safekeeping order. Fifth, because a factual finding was required to authorize the safekeeping order, a hearing with notice to the parties on Sheriff Lesenby's safekeeping request was required. So all this stuff is leading up to the point that he was like wrongly imprisoned, tortured, so many of his civil rights violated. And God, I hope I hope his conviction and sentence gets overturned and he gets to sue the pants off of all of the people involved that helped railroad him. All right, sixth, and perhaps most importantly, did I read fifth? Fifth, because a factual finding was required to authorize the safekeep. Oh, I did read that. Okay. Sixth, and perhaps most importantly, Mr. Allen had an absolute right to refuse being transferred to the custody of the Department of Corrections. So he was originally in the sheriff's custody because that's who arrested him, but then um, they transferred him to the Department of Corrections. Sheriff Lesenby's safekeeping request alleged no statutorily authorized basis for a safekeeping order other than a concern for Mr. Allen's personal safety. If the reason for a safekeeping transfer is only a defendant's personal safety, the defendant may refuse transfer, which he wasn't given that option and he had a right to do so. Mr. Allen had no opportunity to exercise his rights to refuse the transfer to the Indiana Department of Corrections custody or to make any of the objections set out above the entire course of the proceeding. This is for a quite simple reason. Mr. Allen, either personally or through his lawyer, Mr. Gibson, had no notice of the legal skullduggery that would land him in solitary confinement at the Westville Control Unit, Wabash Valley Correctional Facility, and Cass County Jail for 23 months pending trial. Because Mr. Allen had no notice of what was afoot, neither he nor his lawyer could make any of the arguments that would have necessarily prevented his transfer. So I believe he was I believe that they purposefully and willfully kept his attorney out of it and kept him in the dark so that they could transfer Allen to solitary to try to get a confession out of him. And I fully believe that. I don't have any doubts that that's what they were trying to do. Finally, Mr. Allen's own absence from the safekeeping proceedings should be treated no differently from the absence of a lawyer to represent him. Indiana courts hold pro se litigants to the same standards trained lawyers. Same standards as trained lawyers, I'm assuming that's supposed to say. One consequence of this should be that the Sixth Amendment and Article 1, 13A of the Indiana Constitution should apply when a pro se litigant is excluded from a proceeding at which he or she has the right to be present and participate in. It is a violation of the Sixth Amendment to completely deprive a defendant of counsel at any critical stage of criminal prosecution. The safekeeping proceeding, such as it was a critical stage at which Mr. Allen had a Sixth Amendment right to have his lawyers interpose all the objections to the November 3rd safekeeping order set out above. A critical stage is one holding significant consequences for the accused. Because Mr. Allen was entirely and unconstitutionally deprived of counsel at the safekeeping proceeding, the court must presume Mr. Allen was prejudiced by the deprivation of counsel. Alternatively, of the Indiana Constitution provides in part, in all criminal prosecutions, the accused shall have the right to be heard by himself and counsel. Section 13A affords citizens ever greater protection than its federal counterpart. Not only does 13A guarantee a criminal defendant the right to counsel at any critical stage of the prosecution, but the rights afforded under Section 13 also attach prior to the filings of formal charges against the defendant. And I missed a footnote somewhere. Okay. So the court need not speculate whether safekeeping proceedings have serious consequences for the accused. So they don't have to speculate. Good, you can probably assume. In addition to being moved hours away from his lawyers for over 23 months, Mr. Allen was unconstitutionally kept in solitary confinement in an Indiana Department of Corrections prison and was shackled, leashed, and hooded and deprived of human contact. Violation of due process for pretrial detainees to be kept in conditions amounting to punishment. As a consequence of that torture, Mr. Allen became psychotic short of his death. It is hard to imagine more serious consequences for Mr. Allen flowing from the November 3rd safekeeping proceeding. There you have that footnote. All right. Mr. Allen was not afforded either the right to be heard by counsel or by himself at the safekeeping proceeding. This should be particularly disturbing because he had been given the opportunity to do so, or had he been given the opportunity to do so, Mr. Allen had an absolute personal right to refuse the transfer to the department's custody. In either case, accordingly, the court should vacate Mr. Allen's convictions or set this motion for a hearing. In violation of the Due Process Clause of the 14th Amendment and Napue versus Illinois and its progeny, the state presented the testimony of Brad Weber that Mr. Weber arrived home in his white van around about 2:30 p.m. on February 13th, 2017, either knowing that testimony was false before it was elicited or failing to correct it once it had been elicited. So they're saying the state presented false information, or at least allowed him to give false information and not correct it. So, a conviction obtained through use of false evidence known to be such by representatives of the state must fall under the 14th Amendment. The same result obtains when the state, although not soliciting false evidence, allows it to go uncorrected when it appears. At trial, the undisputed evidence was that LG's cellular telephone stopped moving at 2:18 p.m. on February 13th, 2017 for 7 minutes until 2:25 p.m. It then started moving again and stopped moving permanently at 2:32 p.m. In closing argument, Mr. McLellan called it a hard fact that LG's phone stopped moving at 2:32 p.m. The state introduced an alleged confession by Mr. Allen to Dr. Monica Walla, a psychologist contracted by the Indiana Department of Corrections to treat inmates at Westville Correctional Facility. In this alleged confession, Dr. Walla stated Mr. Allen said that he had abducted LG and AW on the south side of the Monon High Bridge and forced them down the hill on the south side of Deer Creek. Dr. Wallace said Mr. Allen said that he was on the south side of the Deer Creek and was planning on essaying LG and AW when he was interrupted by a van. This is part of the so called confession that she wrote down but then destroyed her notes, and this is all from her memory now. So she's very not credible. She was talking to a certain individual, another YouTube creator, Gray Hughes, who's very pro prosecution, has been the whole time, had been leaking information that would be coming out in documents before they even came out. He knew things before they came out. So he definitely had a source, and it's very possible that it could have been Dr. Walla, especially because this van topic came up many times with this Gray Hughes also around this time. So Dr. Walla and Mr. Allen said he became scared when he saw the van and crossed Deer Creek from south to north from the Weber property to Ron Logan's property, taking LG and AW with him. So if you recall, Ron Logan is the individual whose property the girls were actually found on, and Ron Logan is deceased at this point, but he was looked at. The FBI seriously did look into him, and we're going to find out a little bit more about uh, how creepy he is. All right, so the state also introduced the testimony of Brad Weber that he left work at the Subaru factory in Lafayette, Indiana at 2:02 p.m. on February 13th, 2017, and arrived home in his white cargo van at about 2:30 p.m. From Mr. Weber's testimony, the state argued Mr. Weber's arrival home in his van was what interrupted Mr. Allen, causing him to take LG and AW across Deer Creek to take their lives on Ron Logan's property. The arrival of Mr. Weber's van at 2:30 was a detail only the perpetrator who took their lives would know, said the state. Um, so the timeline is critical here because Brad Weber's lying, and there's no way he could have made it, and there's no way that that was him. But they're saying because Brad Weber was coming home and driving into that little hidden private driveway that Richard Allen saw him, and he got scared and decided not to essay the girls and to just take their lives instead, while undressing them and then redressing Abby, but not Libby. And then putting a bunch of sticks on them and, setting the scene to make it look like a Odinist did it. So they wouldn't look at him. Seriously, like the state's theory just makes no sense. But the timeline is going to be critical here. So the problem is the state also contended that LG and AW died near uh, in time to the 2:32 p.m. when Apple Health data from LG's phone showed that the phone stopped moving. That doesn't necessarily mean that that is when they actually were deceased. It doesn't mean that that's the actual time. It just means that that's when the phone stopped. So a phone and a human can be separated, and it's possible that a human can continue living on while a phone doesn't move. So there is that If the arrival of Mr. Weber in his van interrupted Mr. Allen, forcing him down Deer Creek, Mr. Weber would have had to arrive near his parents' house at the end of the private drive before 2:32 p.m., when, according to the state, the phone stopped moving and was located on the north side of Deer Creek. In fact, Mr. Weber could not have arrived anywhere on the private drive before 2:44:54 p.m. on so there you have it. So the timeline, he couldn't have arrived at that spot until 2:44 p.m., not the 2:32 that he says. So his arrival at about 2:30 could not have been a detail only the perpetrator would know because it did not happen. So he lied about the fact of the time of when he got home, and so that couldn't be part of the state's theory. It just doesn't line up. The state knew or should have known as much, and the state either elicited Mr. Weber's testimony about the time he arrived home, knowing it was false ahead of time, or they failed to correct the testimony only they failed to correct the testimony once it had been elicited. So either they knowingly elicited false testimony or they made an error anyways because they didn't correct the error because the timeline's off. I wonder if Karen Reed can use this because that's an interesting argument because there's a lot of timeline issues in the Karen Reed case too. So, Defendant's Exhibit 3A, as attested to by Matthew Hoffman in Defendant's Exhibit 3, is a video recording made on February 13th, 2017, by a security camera that was in the house. That was in the house. The video recording was provided to the defense by the state and therefore been in the state's possession. Exhibit 3. So hold on one second, let me get there. All right, so this is Defendant's Exhibit 3A. Defendant's Exhibit 3A, as described in 3A, an affidavit by Matthew Hoffman, is a video file named, and it has a big long name. The file is here. So let's take a look, shall we? Oh, hold on, let me make that bigger. All right, so this is Exhibit 3. Let me make sure it's on, okay, it's on regular speed. Let's see what we see. I'm hitting play. All right, so I just noticed that I missed an exhibit here, which was 1D. I went to 1C and then I forgot to go up to 1D. So this is an email from Brett to Brad. Brett Gibson to Brad Rosie, the original attorney that Kathy had hired to Brad. So he says, "Hi, Brad. Attached is a letter I sent to the Carroll County Sheriff's Office and an email I sent to Nick McClelland on October 27th regarding your questions. Did you ever, hold on." He says, "Regarding your questions, did you ever communicate in a way with the prosecutor or any law enforcement officials before Richard's arrest?" He says, "No. Did you ever communicate in a," so these are Brad's questions to, what's his name? Brett Gibson. So these, he must have reached out and asked these questions. So he asks, "Did you ever communicate in any way with the prosecutor or any law enforcement officials after Richard's arrest?" He says, "Yes. On October 27th, 2022, Kathy notified me that Richard had been arrested. We sent a letter to the Carroll County Sheriff notifying them of my representation. The sheriff confirmed receipts over the phone. However, the jail advised that Richard was not an inmate." Very, very bizarre. Uh, I, con- I contacted prosecutor Nick McClelland by email. He called me on my cell phone afterwards. He advised me that Richard Allen was in the Carroll County Jail and that they had him listed under a different name or alias. He arranged for me to meet with Richard at the jail that evening. Someone from the sheriff's office took me to a meeting room in the jail. It appeared that regular jail staff did not know Richard was even there. Let me know if you have any questions. All right, so um, the next couple of exhibits are going to be photos. That's a photo of Brad's uh, van, his white van that we're saying that we see. Here's some images. I'm going to really zoom in. So we're going to see a video, and this is where you're going to want to look. So this is zoomed in, and this is where you can see his van driving. It's really difficult to see, but you can see it when it's really zoomed in. I know it just kind of looks like a blur, but that is a car. All right, so let's get these videos up. Hold on, let me switch a route. All right, so I have this queued up. This is the first video of two that we're gonna watch right now, and then I'll show you where you want to be looking. It's right in this area. It's gonna start in about 4 seconds once I hit the play button. It's gonna be about at the 2 hour and well, I guess that's 2 o'clock. The 2 o'clock um, and 44, 2:44:40 is the exact time where you're going to start seeing it move across the screen. So here you go, hitting play. So you can actually see it going. I'll rewind and we'll look again because it's very hard to see, but you will see it. So let's rewind again. And there, you can see it moving. See my mouse a lot better, but that is where it was. So let's look at it from a zoomed in angle. All right, so this is now a panorama and it's zoomed in, as you can tell, where that same area was that we were looking before, but now you can see it a whole lot better once it moves. I'm going to hit play right now. So just keep looking in this area here. There, it just showed up and now it's moving along with my mouse. It's right here. Kind of slow, but it is going, and then you don't see it anymore. Hold on. All right, so now this is zoomed in even more. Let's take a look. Now you can definitely see it. Sorry, I'll flip back a second. The window popped up. Okay, here we go. There it is. You can see it definitely going by right there. That is Brad Weber on his going towards his private road that we've been told is just was the whole reason that the jury thought that Richard Allen did it because he knew about this van or whatever from Dr. Walla, which, as we know, is not reliable. So let's actually read this last little bit, and then I am going to have to call it a night for today, and then I will get to the rest of this tomorrow. I will go through it with you guys and give you the rest of the exhibits. So this is saying the security camera faced northwest, and appears to have recorded continuously. So now we're talking about these exhibits, exhibit 3, 1, and 3B, which we just watched. All right, so 3.1 was the first one where it was not zoomed in. 3B is the zoomed in version, just so you know. All right, so based on the date and timestamps on the video, it appears that the security camera was set to record date and time information as part of the recording. So that time was on there. Time on the security camera was set 12 hours behind, such as 12 a.m. is really 12 p.m. on the same day. So you can just reverse it. So this is apparent due to the daylight and moonlight on the video and the associated timestamps. The security camera had a wide angle lens that captured video of traffic on West 252 North and County Road North 625 West. You guys in the country, can you just like name your roads like normal names instead of all these W252 I catch a niner in there. Tell me what movie that is. So the security camera had this wide angle lens that captured video from all these different roads or from those roads and the beginning of the private drive to Brad Weber's property. So that was going towards Brad Weber's property, which begins as a continuation of North 625 West, approximately 190 feet north, and that road's intersection with West 252 North. So, okay, whatever. Those are the roads that converge, and we get the private road that goes to Brad Weber's house. County roads North 625 West and West 252 North are the only roads by which a vehicle could enter the Weber property. So it is a private access road. According to the time and date stamps on the security camera recording, Exhibit 3A shows a white vehicle going north on North 625 West, entering the frame at approximately 2:44:33 p.m. on February 13th. This exhibit also shows a white vehicle continuing into the private drive to the Weber property at approximately 2:44 and 54 seconds. Exhibit 3A is viewable on YouTube at the following address. We watched it. Exhibit 3B is a video file that contains 3 zoomed clips from the video recording that is Exhibit 3A. Each successive clip in Exhibit 3B is zoomed to a greater magnification. In all 3 zoomed clips of Exhibit 3B, a white cargo van going north on 625 West just after 2:44 and 33 seconds in the afternoon on February 13th, 2017. Exhibit 3B is viewable on YouTube as well. Exhibits 3C is a PDF with still photos taken from Exhibit 3B at each magnification level. We looked at that. Whoops, that's the other one. This is the magnification. So there are 3 magnifications they're saying. So this is magnification 1, zoom level 1. You can see it. This is normal. No, there's no zoom, I think. No, they did zoom it once. Okay, and then twice, they zoom it again twice. You can see it clearly going. I mean, it's zooming, but you can see that it's an outline of a car. And here's the third. It's really zoomed in. All right, so that's that. For each magnification level, zoom level 1, zoom 2, zoom level 3, there are 3 stills showing the white cargo van, in succession of its movement. Number 1, just before it passes the white sunlit house in the background of the west side of 6, whatever road that is, 625 West. As it blocks the sunlit house, and then that was 2 as it blocks the sunlit house, and then 3 just after it passed the sunlit house. Reproduced below is the first still photograph on page 3 of Exhibit 3C, showing circled a white cargo van before it passes the sunlit house on the west side of the road. Exhibit 3D is a photograph of Brad Weber's white cargo van provided to the defense by the state and therefore has been in the state's possession. The photograph of Mr. Weber's white cargo van in Exhibit 3D appears to be at least similar to the white cargo van as it appears in Exhibits 3B and 3C, the zoom video clips and zoom still photographs created from Exhibit 3A, the original security camera recording. Other video files produced by the security camera in the state's possession provided to the defense in discovery and covering the time from 2 p.m. to 4 p.m. on February 13th do not show any other van driving north on that same road into the private drive to the Weber property or traveling east on that road during that time. So there's no other possible cars or vehicles driving by. Exhibits 3A, 3B, and 3C reflect that if Mr. Weber returned home in his cargo white van, he could only have arrived home some minutes after 2:44 and 54 seconds in the afternoon on February 13th, 2017, 12 minutes after the time the extraction of LG's cellular telephone shows. The telephone stopped moving at 2:32. So they're saying the phone stopped moving at 2:32. Yeah, Brad Weber's not home until 2:44. So how did he get scared by Brad Weber's van and do the deed before Brad Weber even showed up? Does that make any sense? So either the white cargo van shown in exhibits 3A, 3B, and 3C is Mr. Weber's, with him arriving home some minutes after 2:44:54 p.m. on February 13th, or it is not. In either event, no white cargo van or any other van entered the private drive to the Weber property after 2 p.m. or at or before 2:33 p.m., more importantly, to scare Richard Allen, supposedly, on February 13th. The time the extraction of LG's cellular telephone shows that the telephone stopped moving. Defendant's Exhibit 3E is a redacted FBI subject information sheet for Bradley Weber and is dated March 3rd, 2017. Exhibit 3, the unredacted version of Exhibit 3E, was provided to the defense by the state and was therefore seen in the state's possession. So let's go take a look at this. This says Defendant's Exhibit 3A unclassified says subject name Bradley Weber. Background: Weber has been staying at his parents' home in Delphi. The home overlooks and is adjacent to the crime scene. Let me repeat that. He's staying at his parents' home, living in a home that overlooks and is adjacent to the crime scene. Significant developments. 2:02 p.m. time card leaving Subaru of Indiana Automotive. On 2/13/2017, Weber's phone pings to parents' address overlooking the crime scene initially at 2:50 p.m. and repeatedly pings around the property until 11:55 p.m. So he's in the area until that evening. And he may not have left, it just might have turned the phone off or whatever. So, all right. So next section says gaps. Did anyone else reside with Weber at his parents' home in the time surrounding the homicides? So they don't have an answer to that. Does Weber have any physical ailments? And does Weber have any connection to or prior contact with the victims? And that is the end of that document. So let's go back here. It says Exhibit 3E, the FBI subject information sheet for Mr. Weber says on 2/13/2017, Weber's phone pings to parents' address overlooking crime scene initially at 2:50 p.m. and repeatedly pings around the property until 11:55 p.m. That Mr. Weber's phone first pings to his parents' address at 2:50 p.m. on the 13th is consistent with the video evidence that they have in Exhibits 3A, B, and C, showing that Mr. Weber could not have arrived home in his white cargo van until sometime after 2:44 p.m. that day. From both Exhibit 3A, the security camera video recording, the Exhibit 3E, the FBI subject information sheet for Mr. Weber, the state either knew that Mr. Weber's testimony uh, about the time of his arrival home would be false. So either the state knew it would be false before it was elicited, or they failed to correct it once it had been elicited. When the state introduces testimony it knows will be false or fails to correct testimony it knows or should know to be false, once elicited, a conviction must be vacated or reversed if the false evidence may have had an effect on the outcome of the trial. And we know for a fact from the M Sheet podcast's interview with the juror, the van was a critical moment in convicting him. It's a critical piece of evidence that they looked at. That van, that white van that supposedly only the killer would know happened to go down that road at a time when the murders supposedly already have taken place. So, how does that make sense? To receive a new trial, the defendant must show one, that there was false testimony, two, that the government knew or should have known it was false, and three, that there is a likelihood that the false testimony affected the judgment of the jury. To obtain Mr. Allen's convictions, the state explicitly relied on Mr. Weber's testimony that the time he arrived home and used that testimony to corroborate Dr. Walla's rendition of Mr. Allen's statement that he became scared after he saw a van, so he took the girls to the north side of the creek and took their lives. This was the only statement allegedly made by Allen that contained any detail of what the homicides of that the ho- any detail of the homicides that might be true. So this was like the only detail that he's ever given that might be possibly true. But we know that Walla was in communication with the outside world talking about this case and internet sleuths, and people like Gray Hughes. So there's that. We have a footnote here that says Mr. Allen also said that he shot the girls in the back and buried them in a shallow grave. Neither of the girls were shot in the back, and neither was buried in a shallow grave. He also admitted to taking the life of his family members and y- people who were not dead, like his daughter. So there were lots of confessions he made that weren't necessarily true. So alternatively, the state therefore cannot show Mr. Weber's uncorrected false testimony about the time he arrived home did not have about the time he arrived home did not have an effect. Hold on, let me start that sentence over. That really confused me. The state therefore cannot show Mr. Weber's uncorrected false testimony about the time he arrived home did not have an effect on the outcome of the trial. Okay, I don't know. That's bad grammar there. Whatever. I read it as is, and that wasn't me. Alternatively, were the court to find that the state did not know or should not necessarily have known about Exhibits 3A, the security camera video, and Exhibit 3E, the FBI subject information sheet for Mr. Weber, then both exhibits constitute newly discovered evidence that would probably produce a different result at a new trial. That's the key, is if people had known this information at trial, would there be a different uh, outcome? And it seems likely that there could have been because based on the juror talking about the van, that's what did it for her. Accordingly, for either reason, the court should either vacate Mr. Allen's conviction altogether, that is the proper remedy, Or they're asking, if you don't want to do that, then set a motion for hearing. And that's where I'm going to leave you. We will continue with Ron Logan and his confession. Yes, Ron Logan confessed to of the crimes of taking the girls. And the things that he says sound a lot more accurate than the stuff that Richard Allen was saying. So we will get to that in part two. I apologize to keep you hanging, but hey, that's all right. You're gonna be wanting more. So don't forget to subscribe, hit the like button, and I will get this to you as early as I can tomorrow. I don't have I don't have it within me to sit through this whole thing today. So thank you guys so much for reading along with me. Check the notes below and you can download all of the documents yourself. So, thank you again. Hit the like button on your way out if you don't mind, and I will see you guys next time. Take care. Bye now.